Right, welcome back. This is the capsule on the case of Vriend v. Alberta. And this is a capsule where everything's already on the board because I had a technical issue and I'm going to have to record this again. So hopefully this is going to be the best performance of the semester because I've had a first kick at the can. So how is this case positioned within what we've learned so far? Well, we looked at subsections 15.1 and 2, the two parts of section 15 of the Canadian Charter, which protects against race discrimination and furthers the right to equality. Importantly, it furthers the right to equality. It doesn't just prevent the government from doing things, but it's supposed to be considered within a substantive equality paradigm. So we don't just want the government to further any kind of equality, to treat everyone the same. In fact, the Supreme Court's recognized multiple times in the cases we read that treating everyone the same might be a violation of equality, because it doesn't take into account the unique circumstances of various individuals that make them face different barriers in life. Supreme Court says, as a result of that, we also have 15.2. 15.2 says the government can have an ameliorative purpose. The government can try to do something good, and to the extent that it's trying to do something good, that is going to be saved under 15.2. even where it's otherwise discriminatory. So there's this test under 15.1, very simple. First, there's a distinction. Second, distinction is discriminatory, Distinction is differential treatment. As we said, doesn't really matter all that much who you're being treated differently from, but it does matter that it has a comparative aspect to start with, namely that you get treated differently than someone. Subsequently, we consider whether that distinction is discriminatory. And as we said, there's no hard and fast rule or test, that's been set out by courts as to what it means to be treated differently. So essentially, we look at various indicia, which were set out most helpfully in the Law v. Canada case, where the Supreme Court said we recognize that discrimination and equality are fundamental principles that are hard to define, where we can't have a simple test as we do under other subsections. Under sections, of the Charter. And that's because they appeal, according to the Supreme Court, to the highest human ideals, and therefore are intrinsically, by design, hard to pin down. And so the court, in the Law v. Canada case, is going to give you a bunch of indicia, a bunch of things that you can look at to see whether there's discrimination, and these things are not going to have to be cumulative in the sense that you have to show, multiple aspects, so multiple ways that the distinction is discriminatory. Instead, generally, they'll be the opposite. You'll only have to show one indicia of discrimination, but you're given a list because the list is not exhaustive, so you can look at other things, and also because that concept, as I said, is hard to pin down. What are the indicia that we considered? First, whether there's a stereotype, I'll just go through the 3 or 4 most relevant ones. First, whether there's a stereotype, whether some group or person is being treated differently because we assume things about them, generally having to do with how we've treated them before, And as a result of that, we perpetuate that disadvantage because we assume things that we've assumed in the past, and generally things that are not true. For instance, we assume Caucasian people are rich, Or we assume Jews are rich, and therefore, we make certain legislative decisions, for instance, not provide them with benefits that have a financial value. That's a stereotype. Second, whether it offends that idea of human dignity, this idea that people need to be treated like people, Not like animals or plants, but like people. And as a result of that, the fact that we don't want, people, even the worst of us in society, to be treated in a way that offends human dignity, because dignity is about the fact of being human. It's about that characteristic that is owed by virtue of your existence as a human being, regardless of who you are and what you do. And so even if you're a murderer, a rapist, we don't do certain things because they offend human dignity. We don't torture you, we don't put you to death, Namely because we think that that violates, our conception of the seriousness of the human experience, as opposed to the experience of other beings. So if a law, right, offends human dignity, and by virtue of that, generally the court says, prevents an individual or group from fully participating within Canadian society. Well, when that is the case, right, the Supreme Court's going to say that there is discrimination from the law case. Lastly, we consider whether, right, we play into historical disadvantage. So when a group has historically been treated poorly, there's no presumption, right? The court's careful to draw that distinction in one of the cases we read, right? To say that there's no presumption, Justice Leroux-Dubé in that sense says that, right? There's no presumption that if you've been historically disadvantaged or marginalized, that that's going to happen again, right? So there's no presumption when you go to court that you are discriminated against that then needs to be reversed by the government. It doesn't work that way. Instead, you still have to prove it, but it's a factor that we consider. So we consider, even though we don't presume, we consider that it is more likely that you'll be discriminated against again because of that historical disadvantage, and by implication, when a law plays into that, right, historical disadvantage, we consider that it is discriminatory. So these are some of the indicia under 15.1. Under 15.2, after a law has been found to be discriminatorily distinctive, we consider whether the purpose of the law that's ostensibly ameliorative, first, is indeed ameliorative. So the government's going to have to show that the ameliorative purpose exists, that it is an ameliorative purpose. Second, we'll consider whether, right, the purpose is rationally related to the way in which the government's achieving the purpose. So we'll consider whether, right, it makes sense for the government to try to achieve that ameliorative purpose by doing what it's doing, for instance, providing benefits to certain people. And once that's the case, third part, anything that is done pursuant to that distinction is going to be valid, constitutionally valid. And so the government can't put a bunch of other things in to try to squeeze them into that exemption. But to the extent that the government is only doing that, right, it's fine. The government is going to, right, quote unquote, get away with that and be able to have that ameliorative program stand even when it otherwise offends the Constitution through subsection 15.1. For the case for this week, we consider, for this session, we consider analogous grounds. So under the test for both 15.1 and 2, right, it's not just any distinction or any discriminatory distinction that offends the Constitution. In fact, there's further requirements, right? Namely that you need to have discrimination based upon an enumerated or analogous ground. And therefore, we don't protect against any type of discrimination. We protect against discrimination based on enumerated grounds. So the things that are listed in both 15.1 and 2. 15.1 says you can't discriminate including based on, and then there's race, gender, and a list of things. These are enumerated, and they're the same in 15.2, listed the same way. These are enumerated grounds. You can't discriminate on that. And there's also analogous grounds because that list is not limitative, as we said. It's just a bunch of examples. It's not a list that is closed, and so you can show similar things, and you might show that to be an analogous ground. And to the extent that the court accepts it to be an analogous ground, then you'll be able to prevent discrimination based upon that. So that adds a step, though, when you have an analogous grounds. In addition to meeting the tests that we look at, 15.1 says discriminatory distinction based on a ground. 15.2 says once 15.1's been applied, namely including with the grounds, then the government has to show various things. Well, when it's an analogous ground, you'll have to show first, before this whole thing happens, under either 1 or 2, you'll have to show that it is an analogous ground. You'll have to show that your ground is analogous before you get the opportunity to apply 15.1 or 2, because they only apply to enumerated or analogous grounds. And the court's going to say there's a test for that. So there's this under 15.1, as we said, discriminatory distinction, right? A ground, why is it analogous? How do we meet that preliminary step? And you'll recall you only have to show it once. So once a person in a precedent has shown that a certain ground is analogous, then it's fine. It doesn't have to be shown again in future cases. But of course, you'll still have to show discrimination on that ground, as you would for any other ground. So, has precedential value, right? Once a court says it's an analogous ground for future cases, you can assume it is because the court said that. It's the same as if it had been listed in the original list from 1982. How do you show an analogous ground in that first instance, right? The court gives indications. They're generally a characteristic, a human characteristic, a part of who you are, your identity, that is fixed, right? And the court's going to say, well, fixed or can't be changed except at an unreasonable cost. That might not really be the best way to put it today based on social mores, but basically, right, if you have to, say, get surgery to change your sexual orientation, that seems to be what the court's referring to, that's going to be an unreasonable cost, and it's going to be as if you couldn't change, right, not your sexual orientation, your gender. And therefore, it's going to be potentially a ground, right? So something similar to gender would be an analogous ground. Gender is an enumerated one. And second, it has to meet that purpose of substantive equality, because as we saw, that list isn't random, right? That list lists things, right, that either we traditionally discriminated against or things that are useful in furthering substantive equality, which is what underlies this entire paradigm. And finally, right, we try to address discrimination specifically for this historically disadvantaged groups, not just anybody, right, not Caucasian people generally. And that's also why we saw, right, in various cases, including the Gosselin case, right, discrimination based on age, a person was not disadvantaged. She was young. And young people, contrary to other marginalized groups, are not historically prevented from participating in Canadian society, right? And therefore, the distinction might not be discriminatory. So, what happens in the case, right? Well, we have Mr. Vriend. Mr. Vriend has a job. By all accounts, Mr. Vriend is doing tremendous at his job. So he's had raises, he's had positive performance evaluations. So no reason for Mr. Vriend to be fired. In fact, the employer seems to think quite the opposite, right? Mr. Vriend should be promoted because he's a good employee and has been in the past, has been promoted, right? And Mr. Vriend is something that might seem very usual. Goes to his employer and says, essentially, I'm gay. And the employer, by virtue of that alone, fires him. Really, the employer asks him to resign, then he refuses, and then he's dismissed. The employer dismisses him because he's gay. For that reason alone. Not based on merit, not based on who he is, right? As an employee, just based on who he is as a person. Because the employer has a policy against homosexual, I think, choices. The language very indicative there. And therefore, the employer says he's entitled to fire him. Well, Mr. Vriend, of course, thinks this is not fair. So Mr. Vriend does the thing people usually do when they think it's unfair, and they turn to the law. The law is the only thing to protect Mr. Vriend there. Mr. Vriend looks to the law and says this is discriminatory. But there's no law for Mr. Vriend to resort to. First, as we'll see, Mr. Vriend can't resort to the Constitution because the Constitution doesn't apply by default to reports between private individuals. So in that case, Mr. Vriend's saying my employer discriminated against me, specifically in terminating my employment. But the Constitution, right, only applies, the Charter only applies, as we saw, generally to public action and specifically for 15 to laws, right, to some action prescribed by law, and that has broad definitions we saw, but, right, still narrower than public action. Under either definition, the relationship between Mr. Vriend and his employer is not covered by the Constitution. In other words, Mr. Vriend doesn't have a constitutional 15 right not to be discriminated against based on his sexual orientation from his employer. There's a law, though, in Alberta called, right, the Individual Rights Protection Act. So Alberta passed a law to recognize that. It said, well, it's not fair in a free and democratic province such as Alberta that we don't have an instrument that protects that protects these specific these specific reports between either individuals and companies or private individuals amongst themselves, and therefore we'll pass a law that says you can't discriminate in that context, and that's absolutely allowed, right? Of course, that law, as we'll see, will have to comply with the Constitution. But there's nothing preventing provinces from doing that, and in fact, lots of provinces do that, right? They'll pass laws, generally human rights codes or some other form of anti-discrimination legislation, that's going to fill in the gap in the application, generally, of federal law, of the Constitution, of the Charter. As we said, we focus only on 15 for the purpose of this course because it's the most relevant. It's what invalidates laws because the Constitution is senior to other laws, as we said, generally because of how it's been adopted, right? And as a result of that, it's more, it's applied to a greater extent in the context that we consider. And also because the interpretation of Section 15 is help the interpretation of human rights codes because these provincial pieces of legislation were passed after generally the Constitution, and therefore the interpretation of 15, right, has been useful in filling in the gap. So when the provincial government passes a brand new law that no one knows how to interpret, right, it's going to make sense to resort to federal law where similar provisions have been interpreted. So that's why our focus is on federal law, but it's important to keep in mind, as we said in the very first week, that there's a much greater ambit of legislation that protects equality and prevents discrimination, and that includes provincial laws. So in that case, Mr. Vriend doesn't get to use the Constitution, gets to use, perhaps, a provincial law that provides a similar protection, in that case, the Individuals' Rights Protection Act of Alberta. So Mr. Vriend wants to go to court, go to some tribunal, right, and say, I've been fired discriminatorily. I've been fired specifically on the basis of and solely on the basis of my sexual orientation. And that's not fair. If I had a different sexual orientation, I wouldn't have been fired. That's discrimination. But unfortunately for Mr. Vriend, the Individual Rights Protection Act of Alberta doesn't say that. It says you can't discriminate, including in that context. So, including in the context of terminating employment. You can't discriminate based on a bunch of things. But it's not notably based on a bunch of things, like it is for Section 15. It's not a list that is open to analogous grounds. It's just a list. And by virtue of what courts usually do with grammar, language, right, interpretation, that list, if it contains an and at the end and doesn't have among others at the beginning, is considered to be limitative, to be a full list that you can't add to by default. And Mr. Vriend, right, doesn't have the right under this law to sue for what he's alleging because the list does not include sexual orientation. So Mr. Vriend does the only thing he's allowed to do in that case and contests the law itself. So Mr. Vriend, of course, couldn't use the Constitution in his relationship with his employer, but he can use the Constitution in saying, I should have a right by virtue of that provincial law to sue my employer. Because that law is public action. Now it's no longer the relationship between Mr. Vriend and his employer, it's the relationship between Mr. Vriend and the state and the law. And that's public action. Even though it's from a provincial government, it's public action that is subject to the Constitution and therefore the Charter in Section 15. Mr. Vriend said, the omission of sexual orientation from that law violates my federal constitutional right to equality and be free from discrimination. And therefore, the law is not valid. Specifically, as we'll see, it's more saying that should be added as a ground as opposed to striking down the law. But the underlying reason that justifies that remedy is the same. Interestingly, it's a case from 1998, so very old, midway through the interpretation of the Charter of Section 15 as well in modern Canadian constitutional law. And the court underneath, so the Alberta Queen's Bench Court, so the first instance Superior Court in Alberta, so you don't go to the Supreme Court at first, right? You have to make your way there. First, Mr. Vriend goes there, right? The Alberta Superior Court says, yes, you're right, that shouldn't have been omitted. That violates your Section 15 right. Then, of course, the government goes on appeal because the government passed this law because it's convinced it is constitutional. And the Court of Appeal reverses that. Then Mr. Vriend appeals to the Supreme Court, asks for leave to appeal to the Supreme Court because, as we said, you don't have a right to go to the Supreme Court. You've got to ask for permission. That's leave. Mr. Vriend asks for leave to go to the Supreme Court. Supreme Court says, yes, Mr. Vriend, welcome in. And gets a second opportunity, a third opportunity actually, to contest that law and have the latest verdict, the latest ruling, from the Alberta Court of Appeal reversed. The Supreme Court says, yes, you're right, Mr. Vriend, the Alberta Court of Appeal was wrong, and that is discrimination under the meaning of Section 15 of the Canadian Constitution. And that is so, even if it is an omission. And we have to be very careful here because the court uses that language of omission in a way that's very misleading. Because it's an omission, it's not really one. So it's an omission in a narrow sense, in the sense that the words sexual orientation are omitted from the provisions because the provisions say you can't discriminate based on A, B, C, D, and that list does not include sexual orientation. So in that narrow sense, sexual orientation has been omitted from that provision. However, it's not an omission in the sense of what we looked at as a positive duty to act. In the case of Auton v. BC, which was this case about funding for autism services. And the claimant said, you need to fund services for autism, that specific class of services. And the court said, this is not an exclusion. It's not as if you're asking for a medically necessary treatment, which you have a right to. In that case, it would have been discriminatory. You've got a general law that says you get health care that is necessary. Then you say you don't get your necessary services as an autistic kid. That would have been a differing impact of a facially neutral law, as we saw, based upon an enumerated or analogous ground. What happened there, though, is not that. It wasn't a necessary service. It was an additional service, which the government, according to the court, had no obligation to provide in the first place. And therefore, the court said, you don't have a right to that in the first place. And even if the government provides some other service to some other group, or even to autistic kids, it doesn't obligate the government to do more. And therefore, the court found there's no positive obligation to act. The government doesn't have an obligation to create a new law to remedy discrimination. It has an obligation to have its current laws be constitutional for them not to be struck down. Doesn't have an obligation to pass a new one even if there's discrimination. Even if you're right to say, my status sucks, I want more benefits, the government doesn't have an obligation to respect that. So the court framed it as not an exclusion from a facially neutral law, which would have been unconstitutional most likely, but frames it as just if someone went to court and asked for something, as if there were no scheme for autistic kids at all, and then some autistic kids went to court and said, we want funding. And the court would have said there's no positive obligation to act. So in that sense, an omission to legislate, an omission to provide services is not offending the charter. Because the government doesn't have an obligation in the first place. Even if it's discriminatory, there's no obligation for the government not to act discriminatorily in that failure to act context. And as we saw in the Cunningham case, which reiterated the 15.2 principles, the court's very strong on that. The court very strongly says, otherwise the government ain't going to do anything. If the government doesn't have the opportunity to provide benefits to certain people, the government's going to be, quote, paralyzed. That's a word from Cunningham. It's going to be, quote, paralyzed, and it's just not going to provide services to anyone. And that's bad. It's bad in achieving substantive equality, and it's certainly bad in applying the 15.2 ability to pass ameliorative programs, because obviously the goal of 15.2 is to have the government do what it says, to pass these ameliorative programs that 15.2 empowers the government to pass. Here, significantly, it is considered to be a facially neutral law, a neutral broader law, as we saw, right, that excludes someone. So it's not as if the government had passed a law that says you can't discriminate against transgender people. That would have been fine under 15.2 in the same way as we just saw, because it's a specific group of people. It's not everyone except a group of people. The more people you add to the number of groups, the more likely you get, the closer you get to something that's not 15.2, to something that's not tailored to help a bunch of people, but that gets more and more general, such that the exclusion from that more and more general proposition is likely to offend the Constitution, because you're drawing a distinction and excluding specific people, as opposed to excluding almost everyone from a law that helps a particular group. So here, this is not what the court says is going on. This is not a law, right, that omits, it's not a law that protects, say, transgender people. This is a law that protects everybody except for Mr. Vriend. This is a law that says you can't discriminate based on being, right, of a certain gender identity. It's a law that says you can't discriminate based on race, religion, all sorts of things, but doesn't include sexual orientation. So in that sense, it's the same as if you had the law that we talked about that says you get benefits unless you're a Jew. That's an exclusion in a law that's not allowed, because it's everyone except someone, and that exclusion is discriminatory. And here, even if it's phrased differently, here it's phrased as you get benefits if you're a Christian, a Buddhist, a Sikh, right? But not if you're a Jew. Well, then that law is phrased differently, but the result is the same. You've got a general law that includes everybody except for a group, which essentially means it's excluding a group. It's drawing a discriminatory distinction for that group. And the court says, as we'll see, the wording should make difference when the result is the same. So in that sense, it's not an omission in the sense of that positive obligation to act. It's not an omission to legislate at all, because there's no such obligation as we saw. Instead, it's an omission in a narrower sense. It's an omission to include people from a general group. So it's better phrased as an exclusion, as the same thing as I said. You get benefits unless you're a Jew. Here, you're protected against discrimination based on anything, basically, except sexual orientation. And that is an omission in the sense of being an exclusion, as if it had been phrased differently. And in terms of remedy, the court's going to say that it wants it to be read into the provision. So what does that mean? Right? It means that the court, as a remedy, is not going to strike down the law. We didn't look at that in great detail, not that important, but you've got two sections in the charter that say what happens when a law is offending the Constitution. Because, of course, courts have the power to declare that, but there has to be a consequence, otherwise it wouldn't make a difference. And the court's allowed first to award damages. The standard for that is very high and hard to meet, very unusual for the court to award damages for charter violations. And second, the court can fashion a remedy, generally having to do with striking down the law. That's basically what we saw in most cases. The law is not valid, the government couldn't pass a law that offends the Constitution, the law was never validly passed, and therefore the court strikes down the law. The reality is a bit more nuanced, so the court can do things that are more deferential to respect the role of the legislatures, because as we said, the legislatures have the power to pass laws as long as they're not discriminatory. So the court only says what you pick doesn't work. The court doesn't say, among these other options, this is the best one, even if it thinks that. It's not the role of the court. The court doesn't pick the best option, doesn't show its policy preferences, the court only strikes down what is not allowed. By implication, the government can pick between what's allowed, between the other constitutionally compliant options, right? And therefore, the court sometimes will, instead of striking down the law, right, read in a provision, right, read in a word. So here the word sexual orientation are read in. So it's as if the law had mentioned that. Instead of striking it down, you fix it, quote unquote, because the court thinks that better reflects the intention of the legislature, namely because there's massive consequences here of striking down the law, because the law says you can't discriminate based on all these things. Well, if you say that is not constitutional because it doesn't include sexual orientation, well, what happens? The entire provision is struck down, that strikes down the entire list, and so no one can sue now, including for these other things. And the court's going to say it's clearly not the intent of the government. The government would have preferred to include sexual orientation instead of not pass the law at all. And therefore, we will read it in. So we will add it instead of striking down the law. Another thing you can do is a suspended declaration. So you can say it's unconstitutional, but we'll wait for a year so the government can figure it out. There's a tension there, of course, because you're saying the law is not valid, but you're letting it be valid for a certain period of time. And we see that in the dissent, right? The sole dissenting judge is going to say, not too quick, right? Not too quick, as we assume that that's the best remedy to fashion here. In fact, right, there's all sorts of other things the government could have done, and based on, as we'll see, the clear intent of the government to purposely exclude sexual orientation from the list, it seems likely that the government might have done something else and include the words. And so, the dissenting judge says we should yield a suspended declaration for the government to figure it out, notably because another option is what we call the notwithstanding clause. And we discussed that briefly. We'll discuss it again in our course on Bill 21, but, right, the government is going to be able in some situations, even when there's a breach, or even when you offend 15, and you're not saved under 15.2 as an ameliorative program, and you're not saved under 1, which shaves certain violations to lots of constitutional rights, 2 and 7 through 15. Even when all that happens, the government can still pass a preamble to the law that says this law applies regardless of the Constitution. That's the notwithstanding clause. Applies notwithstanding the Canadian Constitution and whatever infringement might happen. That's an option, and Justice Major, I think, says this is clearly an option that the government might have availed itself of, considering how obviously it is against including sexual orientation in that list. That yields an obvious tension, of course, with the fact that why is it we have constitutional rights if they can be offended in all these tests, has to do with historical compromise, because we have a province called Quebec, which has a quarter of the population and never signed the Constitution, and therefore seems a bit unfair to impose upon, right, everyone a Constitution that Quebec did not sign. And so the notwithstanding clause might be a product of that historical compromise. So again, the remedy that is picked by the majority is a reading in, but that's also criticized by the dissenting judge. Then there's an interesting standing issue that's discussed at quite some length, right, which is interesting, right? So as we said, you have to have standing to go to court, including the Supreme Court. So as we said, you can't go to court and say, my neighbor's rights are going to be infringed. You can't either go to court and say, my rights are going to be infringed someday, or I think they will be infringed. Because courts resolve disputes, and generally live disputes. So generally you have to have a dispute with someone, in that case with the government. You have to tell the government, hey, this is not compliant. The government generally says no, right? No, you're not correct. And defends that in court. It's a dispute. And it has to be live, in the sense that it can't be moot or theoretical. These are words that are used by courts. So if the government removes the law, well, then you're no longer heard because the law no longer exists. So your issue is moot. Your issue has been resolved, and you no longer have a reason to go to court. So these are two aspects of it, as we said. And that's significant because the role of courts, even when they know that a law is discriminatory. So in that case, even when everybody in the Supreme Court's read the newspaper and knows that this wicked Alberta law is not compliant with the Constitution, right? The court can't just call up a litigant and say, come in and we'll declare it. And the court can't, in the absence of a litigant, say, this is not compliant with Section 15, although it might be true. Here, Mr. Vriend has standing. This is important, right? Doesn't really change the principles that we looked at before, even though it's discussed quite a bit. Mr. Vriend has standing because he's personally been affected. He is alleging that his personal constitutional right to equality and non-discrimination have been infringed upon by the Alberta legislature, namely because he wants to file a complaint against his employer for wrongful termination and cannot do so. So he has standing, and he continues to have standing because the law hasn't been repealed. However, the court's going to expand that. It's not going to make up the standing there. So that doesn't change the principles that we considered. But the court's going to expand it and say, well, while we're at it, we won't just consider the part that says you can't discriminate in the termination of employment, which is a specific provision of the Alberta law that applies. The court's going to say, we'll consider all these other things, because then there's, 20 other provisions in the law that say, well, you can't discriminate in that context either, in that context either, in that context either, and functionally, the result of doing otherwise would have been that you need 20 different people to contest each provision one by one. So the court says, well, they're all drawn on the same distinction, and therefore we will rule on the omission of sexual orientation from all these provisions. But strictly speaking, that might be beyond the traditional standing because these provisions don't apply to Mr. Vriend, and ostensibly, as the dissenting opinion notes, right? Obviously, you don't read the dissenting opinion here, but it's in the head note, so you have a summary of what it says, right? So the dissenting opinion says, right, Mr. Vriend hasn't been, of course, wronged pursuant to these provisions because the only thing that happened to him is he was terminated. It's not that he was hired, it's not that someone didn't bake a cake for him, it's not that there's a sign that says Mr. Vriend sucks because of his sexual orientation, which is also prohibited under the law, right? It's just that one provision. So there might be, according to the dissenting opinion, some different consideration that needs to be considered in a separate case that's not the decision of the majority for the reasons I mentioned. Then there's an argument that the Charter doesn't apply to positive action, for the reasons I mentioned. Won't go over it again. And there's also an argument that the Charter doesn't apply to private reports. But as we said, right, what's happening here is not Mr. Vriend applying the Charter to his relationship between him and his employer. It doesn't apply. This is Mr. Vriend, right, applying the Charter to him and the government of Alberta who passed the law. And therefore, by implication, and this is significant, right, doesn't mean that Mr. Vriend, once the court says you're right, is going to get compensation from his employer. Because the court doesn't say that. The court just says Mr. Vriend should be able to bring a claim based upon sexual orientation under the Alberta law that we mentioned. So even if Mr. Vriend prevails, which he ultimately does, right, he's still going to have to use the legislative mechanism. He's still going to have to go to whatever tribunal the Alberta law says he has to go to and show specifically that he's been discriminated against. In other words, he's going to gain the right to do it. He's not going to be, right, that right is still going to have to be adjudicated in the same way as it would if it were based on religion, pursuant to whatever mechanisms provided for in the Alberta law. Then the court justifies why it is that it's not fair to draw distinctions between what it calls homosexuals and heterosexuals, right? And that's because it relies on a narrow conception of equality. So one of the arguments of the government of Alberta there, perhaps you find it very peculiar even with your 3 weeks of training on Section 15, but the government said, well, you get the same treatment as someone who has any other sexual orientation. Namely, if you're discriminated upon because you're a Jew, you can use the law and say this is discrimination on religion, whether you're of any sexual orientation. However, the court says no, right? This is a narrow formal equality concept that says you all have the same rights. The reality is, if you're of a different sexual orientation, then you might be discriminated against based on that. And that's more likely to happen. It's more likely because of how you've historically been treated in society. It's more likely that someone's going to discriminate against you because you're a homosexual, as the court calls them, than if you're a heterosexual, again, as the court calls them. And as a result of that, it's not fair. And it's not, right, providing the same benefit to the two groups of people. And conversely, saying that, right, people who are heterosexual don't have the right either to sue because of sexual orientation is not a correct argument because it relies on that same formal equality conception, namely because you're less likely to be discriminated against based on your non-differing sexual orientation, and specifically, that's what 15 is there for. 15 furthers substantive equality, and as we saw, right, generally only applies to disadvantaged groups. So the court, to put it, right, emphatically says this is an analogous ground. So it has precedential value. From now on, sexual orientation is an analogous ground that you don't have to show again. We have to be careful, as I said. It has to be said explicitly. In Cunningham, the court was tiptoeing around the issue saying, we don't rule on this because the distinction that was at issue was whether having status pursuant to the Indian Act is an analogous ground. And the court said, right, we don't decide that because the first instance judge said yes, then it wasn't contested, we're at the third level now, and we don't have to rule on that. So it was left open. So just because it was applied in that case didn't make it an analogous ground because the court didn't explicitly say that, and therefore, for the reasons I mentioned, doesn't have precedential value. Then you have an analysis under Section 1. So as we said, Section 1 can save a law that's discriminatory. So even if it did not pass 15(1) and 2, the government can still use Section 1 to save the law. Section 1 has to do with, right, reasonable limitations of constitutional rights in a civilized society. It's similar to the test that we saw in the United States case of Gratz v. Bollinger, I think last session, right, where the court said it has to be, right, first related, the law has to be related to a compelling interest, so something serious, and it has to be narrowly tailored to achieve that interest. In other words, it has to, right, limit constitutional rights as little as possible. And that's because we recognize that constitutional rights have to be limited in society, especially when you have rights that are as broad as the right to equality or life. Lots of things by the government are going to infringe upon your liberty, your life, or your right to equality. And therefore, we don't want to prevent the government from passing laws because the government would be prevented from passing any laws. And furthermore, oftentimes we'll have conflicting rights. And affirming one person's constitutional right is going to prevent another person from having their own constitutional rights affirmed. And therefore, there's no solution that complies with the Charter. So the government, we wanted to pass laws that do things even when that means inevitably limiting some constitutional rights. And second, we want the government to be the arbiter sometimes of competing constitutional rights, because otherwise, right, nothing happens, right? Otherwise, you're stuck in a catch-22 where there's no compliant solution because one infringes upon a person's constitutional right, the other infringes upon the other person's constitutional rights. So Section 1 says basically, right, the same thing as the Gratz v. Bollinger case, right? First, we have to have an interest, a government interest that is, right, that is compelling in the same way, right? So it has to be rationally related to an important government interest. That's the test. So do something that makes sense in achieving that interest. And second, we have to have minimal impairment. Very similar concept there. Minimal impairment means, right, yeah, you can infringe upon constitutional rights, but we expect you to see that you're doing that. And then we expect you to do it as little as possible, because constitutional rights are serious business in Canada. And here, quite interestingly, the court doesn't even get to the second part of the test. There's two steps under Section 1. First, you have to show that, that interest, right, that government interest, and second, you have to show minimal impairment and other things. And here the court doesn't say that it doesn't make sense to prevent all people of differing sexual orientations from having any right to achieve that purpose. The court says there's no purpose. There's no pressing and substantial objective, right? That's what the trial judge said, not the court. The court tiptoes around the issue there, is more careful, and ultimately finds under the rest of the test, but the court says there's no submissions on the objective. So the court doesn't say the objective is not legitimate, right? The court says, well, we don't know what the objective is, and that doesn't really make sense, so it fails at the first step still, not for the same reasons trial judge. And second, right, we don't even have to look at whether it's minimally impairing, because there's no objective that justifies the impairment of constitutional rights. Interestingly, as you'll see, there's far less deference of government decisions than there was in the Cunningham case. So we saw in the Cunningham case, right, we looked at the dissents, right? So Cunningham was this Alberta law. Again, Alberta redeemed itself, it seems, 20 years, or 13 years later. Instead of saying you can discriminate against people on sexual orientation, said we want to give rights to the Métis people. A bit more positive there, arguably. And if you want rights under that, I think it was a Métis Betterment Act, you cannot be registered as an Indian, federal government's word, not mine, under the Indian Act. Specifically because we want this law to be for Métis settlements. We want them to have their community, stick together, have their own identity. And of course, if all sorts of people are allowed to come into that settlement, then they'll dilute their identity. And so we want to further their objective of being culturally distinct. And so the way we do that is to say, if you get membership under the Indian Act as a non-Métis, then you cannot, right, claim protection under the Métis Betterment Act, or whatever it's called. And the court almost mechanically assumes, first, that that's a legitimate interest. That is rationally connected. That's the test, right? As we said, government doesn't have to prove that it's going to be able to achieve what it says it'll achieve with a law. The government does have to prove that it makes sense, right? That the means to achieve the objective is, quote, rationally connected to the objective, right? So it's a sensible way to achieve it. For instance, giving money to people is a sensible way to make them less poor. Giving money is the means, making them less poor is the objective. And the court, from debates in the legislature, because there was a report, right, on how the Métis people were treated, the government took it into account, debated it in the legislature, eventually passed a law that gave them additional benefits. And the court says, right, almost mechanically, yes, the government is legitimately trying to have an ameliorative purpose there. Here the court is far more wary of what the government's saying, because the evidence points otherwise, right? There was a report similarly to the Cunningham case, but it said the other thing. It said that people should be included on within the purview of the law based on sexual orientation, and the government said no. And the government said all sorts of odd things during debates as to why it wasn't necessary to do that. Many of the same things that repeated in court and which were summarily dismissed by the Supreme Court. And so, the court distrusts that subjective, even though it's not really right, not really part of the test, strictly speaking, but the court's more wary because of that evidence, you might say. Again, just my opinion, you might disagree with me. And there's also a discussion in the remedy about, so we said the remedy is picked by the court is reading in, so we add that that ground of sexual orientation. There's a discussion as well of financial burden. So if you had broadened the law a lot, you might have imposed an unfair burden on the government. The government would have had no choice but to, pursuant to that law, which remains valid, cover a bunch of other people, which would have cost billions of dollars, and that would have restricted the ability of the government, one, not to have positive obligations, not to pass laws it might not otherwise have passed, and here government might not have passed a law if it costs a lot more money, and second, to make a decision between legitimate constitutionally compliant options. So to pick the non-infringing option that it prefers, because the court tells the government when the option infringes upon the Constitution, not when it doesn't and there's a better solution. So the court says, basically, right, that if it had been an unreasonable burden, here it's probably not because there's all these grounds, you only add one, the tribunal isn't going to be flooded with requests, right? Therefore, it's compliant with the intent of the government, and reading in is more compliant with both Section 15. So Section 15 says we want to further substantive equality. If you strike the whole thing down and people can't sue pursuant to this Alberta law on any ground, that's clearly not helping anyone be more equal, as opposed to that reading in where we allow more people to sue and don't take away the rights of the others to do it. And the court says, obviously the government, based on its stated intent, and there's a bit of tension there because the court says its stated intent to protect everyone isn't legit because it's excluding homosexuals voluntarily. But anyway, right, court says, based on that intent to have a human rights legislation that prevents discrimination, it's clear that the government would have chosen to read in, add sexual orientation, as opposed to not pass a law at all. And interestingly, we have a concurring opinion from Justice Remedies, who basically says the same thing as the majority in stronger terms, is also careful not to shut doors. So she says, well, we won't say that there's no positive obligations. We'll just keep that for another day, right? It's just 1998. We're only under 20 years from the charter. We should keep our options open to react to future cases. So she's being more careful in keeping options open in the constitutional interpretation of 15, and she's also stronger in her language. Justice Major disagrees on the deference owed to the legislature, right, in his dissenting opinion, and also disagrees on the remedy. But significantly, on the underlying issue, everyone agrees. The whole court agrees, regardless of the opinions they write. They all agree that A, it infringes upon 15, and B, it's not saved under Section 1. So even though they disagree on these issues, or on the language, they all agree that the provision is not constitutional and not subsidiarily valid pursuant to Section 1. And as I said, Justice Major, in his dissenting opinion, invokes a notwithstanding clause. So, we'll do as we always do, right? We'll go through the case in a bit more detail. So, with specific page numbers, 505 and following, you have the facts, right? The details regarding the law, and the specific provision that allows Mr. Vriend, or allows, someone in Mr. Vriend's context not to be discriminated upon based on similar analogous grounds that don't include sexual orientation. Interestingly, the court's going to say at some point, right, that means it has to mirror the Constitution. And that's interesting, right? It means that we have to draft any provincial provision that we need for the reasons I mentioned, right, to apply to private actors, to broaden the ambit of 15 beyond state action. It means that it will have to be drafted the same way as 15. So there's no freedom of the government to pick the option there, because if you exclude people, you'll be thought to have excluded them discriminatorily. As we thought, that's not exactly correct, because under 15.2 you can still have an ameliorative program that covers one group of people. But as I said, the best way to construe this is the more you add, the more likely you'll be considered not to help a bunch of specific groups, but to help everyone but one, and that but one is likely to be discriminatory. So in that sense, you might say, when you have a bunch of groups, so not exactly what the argument Alberta is making there, but when you have a bunch of groups and you're excluding one, then you're likely to offend the Constitution. Because of that exclusion, because that omission is really an exclusion. Even though you're saying we cover A, B, C, and D, what you're saying is we cover everyone but, right? And that difference in language should not be significant, the Supreme Court says. But it is true ostensibly that you couldn't have a limitative list for obvious reasons. So I said the more things there are, the more likely you are to omit someone. So in other words, oftentimes if you have a list, it can be limitative and exclude people if it's long enough. You have the legislative history around pages 506 and following. Very interesting how the Alberta legislature showed to the Supreme Court that, according to the Supreme Court's conclusion, it specifically chose to exclude sexual orientation. Unlike in the Cunningham case where there was a genuine positive intent, right? The court seems to say regardless of the language, regardless of whether it's an omission or an exclusion, the Alberta legislature wanted it to be an exclusion, wanted it to be a specific exclusion of a specific group. You have the provision, the relevant provision around page 514. And interestingly, page 517, this is not in what you were supposed to read, but the court takes judicial notice, interestingly. So we said judicial notice allows the court to consider things that are otherwise obvious. It's dark at night, right? March 7th was a Wednesday, so you don't have to produce a calendar or a sun expert to know these things which are obvious and which we all know. Otherwise, by default, because the court can be seen to be biased in some way, right, can be seen to favor a specific party, right, the court is going to not assume things that are not obvious, because then it looks as if it's favoring one party over the other by assuming that what they're saying is true instead of requiring them to prove it. And that's why the default is, if you want to allege something, you have to prove it to get what you're asking for. Interestingly, as we said under 15, the court seems to be a bit more careful and broaden judicial notice either to the limit of its existing breadth or beyond it. Potentially because when you're at that point, it's often too late, right? At the Supreme Court, you're at the third kick at the can. You can't really add stuff the third time around. And also, it's taken a long time, as it did in that case, right? It's taken years and years and years to try to have Mr. Vriend's rights vindicated. And on top of that, Mr. Vriend likely, right, doesn't have $500,000 to contest the law just to get his job back, right? Probably not worth it. Mr. Vriend probably doesn't have $500,000 lying around to contest laws that he thinks are unconstitutional. And so Mr. Vriend's going to rely on lawyers working for free or for very little money for him. And therefore, right, the court recognizes that and perhaps is more generous in assuming things. And here what the court assumes, right, in a way consistent with what the courts underneath assumed, is that there is discrimination based on sexual orientation. We all know that without a need to prove that pursuant to judicial notice. 523, again, part of something you didn't read, but that's where the court says it's really based on sexual orientation because you can sue your employer or you file a complaint against your employer, whatever the mechanism under the Alberta law is, right, unless it's based on sexual orientation. So it is, right, a specific exclusion. As the court reiterating that the decision of the court below in the same ways I've just mentioned to later agree with it. Then you have the standing issues and the omission issues, which we will discuss again, pages 527 and following. Then you have discussion of the legislative omission again, continues at pages 529, sorry. And following this idea of deference, and the court, as we'll see, uses very strong language regarding its role, right? Doesn't think that deference means omitting a constitutional analysis, and that makes sense, right? So the court's going to say, right, maybe we don't like to strike down laws, right? Maybe we just like to be lawyers in robes and do our job, but this wicked government has said, based on the Constitution, that we have to strike down laws, right? We think that should be done by politicians, but the Constitution says it has to be done by us, right? Very smart people, but who were not elected. But that doesn't make that illegitimate. And that's because the Constitution is in itself democratic, right? The Constitution was adopted because it was the will of the people in 82 to add a charter to it. Namely because in 82 said, right, the people realized we're not perfect. We need a protection that says later on we might go crazy and have these laws that are not constitutional. We don't trust ourselves that much, and so we'll have courts strike them down when that happens. But that doesn't make the process illegitimate or undemocratic, because in 82 when the charter was added, that was democratic. And in fact, it makes the process, right, not deferential, but not deferential in a way that's unfair. It makes it not deferential in a way that's constitutionally designed, right? And further, the court says there's other things than democracy. The court says two things, right? And that's a portion of the decision that's very interesting around the middle, where we have a very textured and detailed discussion of aspirations that are underlain by these broader ideals of democracy and deference in the role and the relationship between courts and governments. And the court says, right, that's not democracy. Democracy isn't just the majority passing a law that's discriminatory, because the majority does all sorts of dumb things. The majority might think that some people don't need rights. The majority might think that providing the same thing to everybody cuts it. The majority might think that you can take away someone's stuff just because you're the majority. That's not our conception of democracy, or at least of a constitutional, legitimate democracy. Our conception is, right, the most disadvantaged among us have to be protected some way. We have to be sure that, right, regardless of who's in government, whether it's someone we like, don't like, right, agree with politically or don't agree with politically, whether it's someone with good intentions or bad intentions, regardless of that, certain things are going to be respected, including the rights of certain minority groups. Because there are things, right, even if, right, we agree with them, we don't want to happen to certain groups of people, and we want these rights to be protected, essentially, almost at all costs. And the court says that's good. The court says that's democratic, right? It's more democratic than having majority tyranny, and also it's more democratic, right? It's more of a, human ideal to pursue a world that is better. A world where, right, we recognize the weakest among us, and we ensure that we comply with their rights, and that we provide benefits that are tailored to their specific circumstances. And you might add that, right, is something that was recognized in 82. That the Constitution provides not just for that, but also provides for the idea that we'll change. We'll change under 15. We'll realize that discrimination is in places that we hadn't seen in 82. In fact, you might say that discrimination is in sexual orientation in 98, but that it wasn't in 82 according to the majority of people. In fact, perhaps sexual orientation was purposely omitted from the section 15 when the Constitution was drafted because no one cared. But 15 is interpreted pursuant to that goal of furthering substantive equality today. It's not interpreted based on what Trudeau père meant when he wrote it down. And so in fact, right, we don't have to consider whether initially it was put there or not, right, or it ought to have been put there. In fact, what we have to consider is whether now, the way we conceive of equality now, of substantive equality, whether sexual orientation should be protected. In 98, the answer is yes. And today the answer, right, which might have been no to in 98, might be yes, based on, say, gender identity or other things where we realize that barriers are faced by people that we hadn't even seen, where our conception of equality evolves, right? And the court says very explicitly, right, furthers the human experience, furthers our development as a species, our ability to treat everyone with respect and move forward as a society that's better, that's fairer. And that's a goal, at least according to the Supreme Court, that's never reached, but that's always sought. Very strong language of the court to that effect, page 531, right? Quite simply, it is not the courts which limit the legislatures, rather it is the Constitution. This is necessarily true of all constitutional democracies. Then 532 and following, you have this discussion of omissions and whether it's significant in that case to have an omission as opposed to, right, a specific explicit exclusion. Then you have a discussion of private activity, page 534 and following. Basically, for the reasons I mentioned, right, Mr. Vriend is not trying to apply the charter to his relationship between him and his employer, but rather to his relationship to the Alberta legislature, which says passed a law that's not compliant with the charter. And that's why the court says, even though in the end that law is going to apply to the private relationship, by virtue not of the Constitution though, but of the law itself, significantly, that doesn't prevent, of course, the charter from applying to what is essentially public action. Then you have this discussion that's further expounded upon pages 535 and following, right? The rights enshrined in 15 are fundamental to Canada. They reflect the fondest dreams, the highest hopes, and finest aspirations of Canadian society, right? You rarely see the court do that. It's not a strictly legal argument. It's very interesting, right? Fundamental importance and the innate dignity of the individual. And the court adds the magnificent, that's the court's objective, goal of equal dignity for all. It is the means of giving Canadians a sense of pride. And that's interesting because, right, court couldn't have said that with, say, slashing taxes. The court couldn't have said, right, slashing taxes brings us closer to our ideals. Because that's not something we all agree on. And the court has to be independent for the reasons we mentioned. But here, right, this perhaps left-leaning in some strict sense conception of substantive equality is specifically within 15. So this is not the court taking a political stance. There's lots of criticism of the Supreme Court in Canada, right, from people who are right-leaning, saying the court strikes down all sorts of things. I think Stephen Harper said it's a sociology course. But really, the court didn't decide to interpret the Constitution that way. The Constitution decided, right, even if you disagree with that. 15 says it's substantive equality, says you can have ameliorative programs. So if the court repeats it, the court's not taking a political stance. The court is stating the obvious, both by virtue of the wording of the provision and by virtue of how it's been interpreted from day one, as you saw from the law case and even earlier case and on, right? This idea of substantive equality, you never had a single judge of the Supreme Court over the 40 years we looked at dissent on that point, on that idea that it's substantive equality, regardless of what they think, what they did before, who they were appointed by, and so on and so forth. Then, you know, it just goes on. 535 and following, right? Magnificent goal. Difficult as the goal may be, it is worth the arduous struggle. It is only when equality is a reality that fraternity and harmony will be achieved. It is then that all individuals will truly live in dignity. Then pages, 539 and following is where the court rejects all of the arguments by the government of Alberta that essentially don't embody that idea of substantive equality, right? So the government says to say that people of all sorts of sexual orientations have access to the same ability to contest discrimination based on, say, religion is based on, quote, a thin and impoverished notion of equality that was rejected in a prior Supreme Court precedent And the way in which an exclusion was worded, that's what I said earlier, should not disguise the nature of the exclusion. So as to allow differently drafted exclusions to be treated differently. Then 546 and following is where the court discusses this analogous issue of sexual orientation being something you cannot change, and therefore analogous to the other grounds that are enumerated in 15.1 and 2, so race, religion, and so forth. Then there's a discussion, very interesting, 551, of identities. The court's going to say, right, we don't just discriminate against you because, we don't just prevent discrimination against you because we think you're a human being, and that irreducible core where even if you rape people, right, we think you're worthy of respect as a human being. We won't throw you in, right, a non-marked grave as we might have done in the past, right? And the court's going to say, interestingly, that allows people to have their identity respected. So one of the reasons why we don't want discrimination on things you can't change is because we want you to be yourself on these things you can't change. We want Mr. Vriend to be able to go to his employer, right, very unassumingly and say, I'm gay, and not be afraid that he's going to be fired, because that means otherwise that Mr. Vriend has to choose between his job and being truthful. Truthful also to himself, right? He has to choose between his job and respecting who he is as a person. And the court says that in itself is an affront to human dignity that prevents people from being who they truly are, and that's why we protect human dignity. And we'll close on that, I think. The various other pages of the decision reiterate these principles regarding the relationship between the court and the government.